Good morning, everybody. Thank you all for joining us. I'm going to sort of slowly start our announcements while we're waiting for everybody to make it in from the waiting room. And I'm going to start us like I do each week with our Zoom housekeeping tips, starting with a request that everybody stay muted unless you need to unmute yourself to ask a question. It just reduces background noise and makes it easier for us to concentrate and hear everybody. And if you are newer to Zoom, which gosh, in the year of our Lord 2025, I don't know who is, but I'm going to say it anyways. Your Zoom toolbar is on the bottom of the screen, probably depending on your device. That's where your audio and video buttons are. So you can start and stop both of those as you need to. You're welcome to keep your camera off or have it on if you feel comfortable being on video. That is also where you will see the chat icon, which might be flashing right now because I just put a message into the chat. Excuse me. The chat is the best way to ask questions today during our Q&A. We might have time for a couple of extra questions from the chat after we get through the questions that were submitted in advance. And the message that I put into the chat does tell you how to submit questions in advance of each week's Q&A. So if we don't get to your question today, or you think of another one between now and next Tuesday or 3 weeks from now or whatever, that's the information in the chat is how you submit a question for the upcoming Q&A at whatever time you're sending it in. Although I will remind you, as we do every week, that we are here to discuss general legal information only, not to give legal advice. So sometimes we get questions that are very specific, where folks tell us a lot about the specifics of their community or give us excerpts of their governing documents or ask about a specific contract that their community is dealing with. Questions like that are really difficult for us to answer in a venue like this because A, you're probably not our client, but B, even if you are, we don't know enough of the specifics. And also C, if we were talking about stuff like that on a public forum like this, we would not be maintaining attorney-client privilege. So I think I probably don't need to explain anymore why we don't do legal advice here, just general legal information. Closely related to this, and a new announcement that we are going to start making every week, is that we are no longer going to take questions from folks who won't identify themselves. So if you have an email address that's like concernedcitizen25@gmail.com or whatever, we are not going to take your questions unless you tell us in the body of the email your name. The reason for this is that we don't know who you are. And occasionally we have received questions, for example, from a homeowner that lives in a community that we represent, asking very specific questions where they're clearly angling for, a specific answer about a situation that we actually have knowledge of because of the client that we represent. And so we appropriately need to decline to answer that type of question from that type of person because of the attorney-client privilege concerns, the confidentiality concerns, etc. So from now on, if you submit a question and your email address might be like granny's, best granny ever at gmail.com, that's fine. You don't have to have your email address match your name. You just have to put your name in the email when you send us your questions. Otherwise, we are going to decline to answer those. I mentioned earlier that the chat is the best place to ask questions today or ask us to clarify something we've said. This is just a very quick reminder, but that's the only reason we want you using the chat, not to have discussions amongst yourselves like we sometimes see on the CAI message boards. That hasn't been an issue for quite a long time, so we probably don't need to remind you about that as much. Moving through the rest of our announcements, we want to remind everybody that WSCAI has a WUCIOA resource guide available for purchase, and proceeds from the sale of the guide are going to support our Legislative Action Committee, which is very grateful for the financial support. We just hired a new lobbyist for the upcoming legislative session. And just like everybody in the world is dealing with sort of tight budgets and increased costs, so is the Legislative Action Committee. So if you're looking for a sort of 30,000-foot view resource guide about WUCIOA and you think that might be beneficial to your community, check out WSCAI.org and contact them about the WUCIOA resource guide. Speaking of WUCIOA, we have been reminding everybody that some changes to the statute took effect for current WUCIOA communities on July 27th of this year. And other provisions of WUCIOA will take effect for everybody on January 1st of 2026. So the WUCIOA for all date isn't until January 1st of 2028, but two provisions in particular. One is the WUCIOA meetings provision, and the other is provisions that have to do with delinquency notices and collections. Those changes are taking effect January 1 of 2026. So please be aware of those. And if you are new to the Q&A and you have no idea what I'm talking about and what those changes might be, peruse the last, say, 2 or 3 months of our Q&A and look in the topic list for each video, because we've talked extensively about both of those upcoming legislative changes. Let's see, I think, oh, we have one other announcement. It's not really an announcement so much as it is just briefly touching on the topic of revisions to governing documents. We have a lot of associations and clients and folks that participate in this Q&A that have asked a lot of questions about whether they are required to revise their governing documents in advance of the WUCIOA for all date in 2028, what the process looks like, who is an appropriate person to help walk them through the process of updating or rewriting completely their bylaws and their declaration. Some of our clients are actually choosing to try to do restatements now before the end of 2025, so that when 2026 rolls around, their documents are already in alignment with the changes that take effect in 2026. I think that's a pretty quick timeline, but if your community is super passionate about doing it, it's maybe possible, probably, I don't know, maybe not at this point. We're midway through October, but I mean, that's still 2.5 months left. There might be some, I mean, I think our firm right now is a turnaround time for a draft of a complete restatement of the bylaws and declaration is about 6, maybe 8 weeks. I think we're on the fast side for that. But anyways, if you are looking at whether to make these changes now, especially if you're looking at potentially like a targeted amendment as opposed to an entire restatement, you should contact your association attorney now to see whether that's even an option with the time that we have left before the end of the year. Bylaws revisions are relatively straightforward and probably could still be accomplished, especially if you're one of the lucky communities that can revise bylaws without a vote of the ownership. And in particular, because bylaws also don't have to be recorded. Amendments to the bylaws don't have to be recorded unless the original is, which some of them are, so that's worth mentioning. And so the short version of all of that, the TLDR is, if you're thinking of amending your documents before the end of the year, chop chop, because it's already halfway through October, almost 2/3 of the way through October. Halloween is soon. So keep that in mind and get on it if that timing is something that you're looking at. I think that's everything for the announcement. So I'm going to go ahead and jump us into the questions because we do have a lot today, and we'll try to get through them so we can hopefully pick off a couple from the chat. Our first question is this: in the approved minutes of board meetings, if the name of the person who took the minutes is missing, could that create any potential legal issue for the HOA? And on a related note, we read in Robert's Rules of Order that the secretary should sign the minutes. Is that necessary? I think the short answer to this question, to both of these questions, is probably not. If the minutes were properly adopted and approved by the board, at a subsequent meeting, that is what reflects the full board's approval of what has been written in the minutes. The minutes are the official record of what happened at the meeting, and once they're approved by the board, the lack of a signature or the failure of the person who drafted them to identify themselves is probably not fatal and probably doesn't create any kind of legal issue for the association. Certainly, the very best practice would be for the minutes to identify the person who wrote them and for that person to sign them or for them to be signed by the secretary. And of course, if your governing documents specifically require certain things for your minutes, then you want to comply with any specific requirements in your governing documents. But minutes are not just automatically invalid if they're not signed or if the person who drafted them doesn't identify themselves in the minutes themselves. Robert's Rules of Order, I think I want to remind everybody that those are great general guidelines for organizations that want to follow parliamentary procedure. They are not required for most communities. Again, unless your governing documents specifically require that you follow Robert's Rules of Order, which I have seen before, but it's not super common. And for most communities, maybe aside from those that are very large or very complex communities, the level of specificity and complexity in Robert's Rules of Order probably exceeds the requirements of most communities. If you are running your meetings in an orderly fashion, if your meetings clearly identify the date and time of the meeting, who was there, the motions made and the votes taken by the board, so you can identify the actions of the board at that meeting, then you're probably fine. Lisa, did you have anything you wanted to add to that?
I guess the only thing I would add is I love this question because some of the minutes I see are missing almost all of these things. And so, the name of your association, the date this happened, some motions, who was there, that's fantastic. The fact that it's missing a signature or something like that may not be critical, but make sure that the actual stuff that happened, who was there, and the name of your association, the date would be wonderful information for us, those of us who look at your minutes, to have in the future.
Yeah.
Okay, next question. When our management company increases the fee for managing our association, does the board need to sign a new contract or an addendum to the contract? And I want to start out by saying that we can't necessarily answer this question to your specific agreement or to your specific association. As Valerie mentioned, we can't give you specific legal advice because we'd have to look at your contract, we'd have to know your association, and that would be legal advice. But I guess I'd say that the short answer is probably not. Most management contracts contain a provision that allows for increases with a certain amount of written notice at the time of an annual renewal. And most management contracts are for a certain period of years, typically. And they would say something like, annually with 30 days notice, the X amount of, this fee may increase. It is possible that your management contract contemplates these kind of fees and changes of fees over the term of the contract. And if you have specific questions about that, I would encourage you to contact your association counsel, or if you have one, or if you don't have one, find one to help you navigate these types of contracts in the future, because that is definitely something you'll want to do. There are other types of contracts, things like elevator maintenance, fire monitoring, and management contracts that have increases that may be written into the contract that would have been approved at the time of the initial signing. And that would certainly not require a new signature or a new document to implement those changes. Changes in the rate of services that are not in the contract would need to be voted on by the board and then reflected in a contract addendum, or have a change order to the contract and then would need to be reflected in the meeting minutes. So if there is something that is outside of the contract that was not contemplated in the initial agreement, I'm blanking on something specific, but if it is not a typical contract term, it was something that has come up later and they're asking you to add that to your contract, that would be something different. That would be a new item. You'd need to then vote on that and have that be in the minutes of your board meeting minute and then voted on by the board. But that would be a separate item. Typically, some kind of a fee, the management, fee they charge for sending a notice or something like that, it may change the year. That would be probably contemplated in the contract. But again, if you have questions specifically about that, talk to your association counsel to help you read through those terms in your contract. Valerie, any questions or anything to add up to that?
No, I think you covered it. Our next question says, under RCW 6490 WUCIOA, which our association has not yet adopted, my understanding is that at least 2/3 of board positions must be filled by election, with no more than 1/3 appointed. Given that many associations, including ours, struggle to recruit candidates for election, and that appointed volunteers often resign within months, has the legislature addressed this common shortfall in any way other than receivership? Is there any flexibility or guidance in the statute for boards operating below their authorized number due to lack of volunteers? So I think actually the provision of WUCIOA that you're referencing does not apply to most boards for associations that have transitioned away from declarant control. So you're probably referring to RCW 6490 410 subsection 7, which it says a bunch of things, but it requires that after the period of declarant control ends, appointed board members may not compose more than 1/3 of the board and have no greater authority than other board members. The appointed board members that are contemplated by this specific section of the statute are those that are appointed by the declarant when the community is under developer control. This is not about appointed board members, 10 years after transition to association control, when there's a whole, there's been 5, 10, whatever new boards between that time and this time, and somebody leaves their position, vacates their board position in the middle of their term. The remaining board members can appoint a replacement to serve out the remainder of that term. These are not the appointed members that this statute is talking about. This statute is talking about board members appointed by the declarant. So I suppose if you are a community that only recently took over control from the developer, and you do have a couple of board members that are still serving that were appointed by the declarant, then you need to be looking at this ratio and have no more than 1/3 of the board be composed of those appointed members. And if you still have more than that appointed number, then you should hold an election so that you can seat a full board that is elected rather than appointed by the declarant. But if you are struggling to fill board vacancies and you're doing so by appointment, it doesn't. We've had communities, honestly, that have struggled for years, have held annual meetings faithfully every single year and have never reached a quorum, or have not never, but haven't reached a quorum for years. And because of the failure to reach quorum, they have been unable to hold an election. And so as board members, resign, sell their property, or otherwise are unable to serve, they leave and the remaining board members appoint replacements. That is a valid board with full authority, just like an elected board. And this section of WUCIOA that caps basically the percentage of board members that are appointed is not about those types of appointed board members. I kind of overlooked the second part of your question, which is there any flexibility or guidance in the statute for boards that are operating below the authorized number? And basically the question of the perennial struggle of how do we get enough people to serve on the board? We do have a question that talks a little bit about this later in the session, so I don't think I'm going to go too deep into this right now. But one thing I will say is that we have answered this question probably a dozen times in the last 6 months. So if this is a question that you need to dig a little deeper into, I would encourage you to look through the videos in our YouTube channel. That's one of the links, or that's the link that I put into the chat. And in our YouTube channel, not the YouTube search bar, but the channel specific search bar, you can put in terms that you think would help you find the videos where we talked about this topic. The struggle to find volunteers to serve on the board. You're certainly not alone in struggling with this. Obviously, it's a common problem for community associations. It is not something that our legislature has addressed, to speak, to your question. So I think I'm going to leave it at that, because we've got a question that talks a little bit more about this second question further along in today's Q&A. Lisa?
Nope, I don't have anything to add to that, so I'll just go on to the next one. The next question is, can you please discuss how RCW 6455030, which is construction defect disputes inspection required, pertains to condo associations, and what an association's responsibility is with regard to this statute? We've had project managers assert that all condo construction projects are required to be inspected, but the statute isn't something that's heard about frequently in the industry, since it's not part of one of the statutes we normally deal with. So I'm hoping you can speak to this. Is it the association's responsibility to ensure inspections are conducted after projects are completed, or is it the contractor's? If it's the association's responsibility, then what scope of project requires this type of inspection? And is a building inspector sufficient, or must it be an engineer? And I'll start by saying that our firm deals with this a lot on our general legal side. I do mostly collections work, so it's not me who handles it, but I know that Ken and Lena and our firm handle quite a bit of construction contracts, construction disputes, and so they do a fair amount of this. 6455, which is the statute we are talking about, was adopted to deal with construction for all types of multifamily buildings and to deal with conversions with apartments and apartments into condominiums. And the statute that the person is asking about, which is 6455-030, apologies, applies to existing buildings only when the cost of a building envelope repair, which is things like siding, roofs, windows, exceeds 5% of the tax assessed value of the building. And frequently, as you may have guessed, major repairs will exceed this threshold. And it does apply to all condos that qualify as multifamily, and it doesn't include duplexes, but you would imagine that condos, most of them apply, qualify as multifamily. And it does not apply to things like construction defects, but it does apply to any work done to the exterior of the building, whether it is to repair a construction defect or it is to replace worn out components, things like roofs, siding, things like that. But more broadly, 6455 requires that a licensed architect or engineer design the specification for the repairs, that a qualified inspector inspect during the course of the construction, and then provide a letter to the local building department that the construction was performed in substantial compliance with the specifications. And then the building department will not close out the permit that was prepared for the construction until they get that letter. So a qualified inspector is defined in that statute. It is not the same as a building inspector, but it does, and it doesn't need to be an architect or an engineer, but often that person is that. But you need to look at the statute to see what the definition of a qualified inspector is. From our office, for a project that is that big, we would often recommend having an architect or an engineer be that qualified inspector because it is a project that big and you want to make sure that the project is done properly. It is often the association that pays for and fulfills the requirements of 6455 as a cost of that repair or a cost of that work. And that's the statute. It does often come up for our clients when they're doing major work. Just you may not realize that it comes up because it is a part of that construction and is a part of doing business. And it may be a silent part that you're not aware of when you're doing a big project like this, that the contractor and the engineers are performing sort of behind the scenes, so to speak, and you just may not be seeing it when it's being done. Valerie, anything you want to add to that?
Nope, I think you covered it.
Okay.
I'm going to move us to our next question. If owners will not take turns on being board members, what recourse do we have other than petitioning the court to assign a receiver? So here we are, the promised next question about what do we do when we can't get enough people to volunteer? This question, like I said, has come up a lot before, at least a dozen times in the last 6 months. So I'm not going to spend a ton of time on it. I'm just going to point you back to looking at previous videos to see the sort of the accumulation of all of our answers on this question. But unfortunately, the short answer is that if you can't get owners to volunteer, you either have to hire more out so that the business of the association gets handled, or you could, I suppose, look at the receivership option as a last resort. However, it is extraordinarily expensive and it does require someone filing a lawsuit against the association and every single individual owner. So you can imagine, I mean, litigation normally is expensive between one individual party and another individual party. If your association has, let's say your association has 50 units in it, and you are naming the association and 50 individual unit owners in addition, that means you have to serve 50 people personally with the law. It increases the cost and the complexity of the litigation significantly. So I think what you want to do is you want to communicate and educate your owners early and often to try to prevent yourself from getting in this position, right? I think part of what you want to talk to your owners about is if we cannot get people to volunteer to serve on the board, we are going to have to pay our management company more or hire a management company, for example, if you don't have one, to conduct the day-to-day business of the association, because board members are not supposed to be employees working 20 hours a week or 10 hours a week. It's supposed to be a volunteer position, and the board's role is really to sort of provide high level, like policy level decision making for the community, not to actually manage the nuts and bolts of every day, like depositing checks and writing delinquency letters and inspecting for violations and, you know, sending violation notices and all of the everyday stuff that is required to run efficiently an association. So I think you increase reliance on your managers, your consultants, your other professionals to perform association functions like maintenance and accounting, some of the things that I just mentioned. And that reduces the burden on the board members, but of course it increases the cost to your ownership as a whole. And maybe talking about that potentially increased cost ahead of time creates some incentive for some owners to volunteer to serve on the board. I will offer that, like I said, the receivership option is available. However, we've only ever seen it done once, actually. So our firm has been in practice for 23 years. Ken's been doing this for 23 years. I've been doing it for 17 years. Only once have we seen a client where a bank owned about half the units in the community actually be put into receivership by the courts. So it's exceedingly rare. It's extremely expensive, and you should do everything that you can to avoid getting to that place. So some of the things that this includes, like I said, educating your owners about what boards are supposed to do and what they're not supposed to have to do, about the time commitment that is involved, about the increased cost to the community if more volunteers are not available, and appointing people to fill empty positions. So like if you're supposed to have a board of 5 people and you're already down to 3 right now, don't wait for the next election. Don't wait for volunteers. Start going proverbially, door to door, metaphorically, whatever. You can call people, email them, whatever. Be really proactive about trying to get people to agree to be appointed to fill those vacant positions. So you don't let yourself get to the point where you're down to one board member who's now selling their unit and, oh my gosh, what do I do? Right? Because that's a situation you don't want to end up in if you can avoid it. Short of that, I guess those are really your options, I think. I don't want to go too much into detail, like I said, because we've talked about this question so many times in the past. So please look at our previous videos. And if your community is facing this situation, I would strongly encourage that your board talk both to your manager, if you have one, and to your association attorney as well. If you have neither, get both, so that you can sort of avoid sort of the worst possible outcome that you might end up in, which would be the receivership, which is crazy expensive and nobody wants that. So Lisa, did you have anything that you wanted to add to that one?
Nope.
All right.
I'll go to the next question. If an HOA board is deeply divided in a Hatfield-McCoy kind of way, and the majority makes a possibly unlawful decision, do the minority have a right to seek advice from the HOA attorney without a board vote? If so, who pays the attorney fee? If not, what is the best practice for minority members to protect themselves and the association? And this is another time where I'll start again. We're just giving general advice, not specific legal advice to this association. But I will start out by saying that minority board members do not have the authority to contact the association council without the full board authorization. So you'd need to have a vote by the board to approve contact with, or to approve action contact to the association's council. And if the board is unable to agree on contacting the association attorney, it may be that the minority or individual board members need to hire their own counsel and pay for their own attorney to give them advice on what they need to do, whether the action was unlawful, and what their recourse may be. If they hire their own attorney, as I said, they would need to pay the fees for that attorney. It is possible, we have seen in some cases, a board might agree, if it is demonstrated that the minority was correct somewhere down the line, that the action was unlawful and the board agreed with that fact, the attorney fees could possibly be paid for in the future, but I think you would have to expect that the fees would be paid for by the minority. I would agree it's not a great situation to be in, but that is probably your best tack, is to hire your own counsel and see if you can work some solution that way, and see what advice they can provide to you. Again, not a fantastic solution for you, I apologize, but that is probably your best approach, because you don't have the authority to contact the HOA attorney on your own without authority of the full board. Anything you want to add to that, Valerie?
Yeah, if an individual board member contacts our office, the first question we ask them, unless they're unless they have previously been our approved contact for the board, is do you have the board's authority for us to charge the association for the advice that you're asking us for? So we asked that question. I mean, Ken just had a conversation with an individual board member who contacted our office a few days ago for one of our clients and was doing so in their individual capacity and not with the authority of the board. And that was a very short phone call because Ken asked that question and was able to identify that quickly and said, I'm sorry that we're not going to be able to answer your questions unless you get the board to agree that this is an authorized expense. So it's not an option for the minority to seek the advice of the association's attorney without the authority of the board as a whole. Put differently, we have said this many times in many different sort of scenarios that we've talked about in the Q&A over the years. As an individual, you don't have any authority. Your authority as a board member comes from when you as a board take action together. Unless the board votes to delegate specific authority to an individual member, you don't have any authority outside of when you take action together with the board as a whole. And so this is no different than that. All right, next question. There has been some debate in our office about a couple of perceived upcoming changes. If an association has a special assessment, can they pass any administrative fees on to the owners? And will there be a minimum contribution threshold for reserve accounts in the coming years of WUCIOA for all? On the question of the special assessment administrative fees, if the fees are reasonable and they are disclosed to the owners during the special assessment ratification process, they can probably be passed on to the owners. If they are unreasonable or if they are not disclosed to the owners during the ratification process, we think the authority to pass those costs on to the owner is much more tenuous. On the question of minimum reserve funding in Washington state, there is currently no such requirement in WUCIOA or any other statute. And it has come up in the legislature in recent years. It hasn't gained enough traction for a bill, I think, to make it to the floor for a vote yet. And CAI National definitely opposes any such requirement for a variety of reasons. And you can read their policy paper on why if you go to their website, which I think is caionline.org. As far as banks, though, it might be worth noting that banks still look at 10% of the annual budget as being the minimum that they consider reasonable when they're looking at whether to provide a loan to an association to individual owners or purchasers who want to buy a property within a community. So if I'm trying to buy a condo in a community and I'm trying to get a loan from, Wells Fargo. Sorry, why couldn't I think of a bank just now? BECU, that's a better one. If I'm trying to get a loan from BECU to buy a unit in a condo association, they're going to look at the financials for that association and they're going to be looking to make sure that association has a minimum of 10% of the annual budget amount in its reserve account before that bank is going to be willing to loan me money to purchase a unit in that community. So that is an industry piece of information that's helpful to have, but it's not a statutory requirement. So, and again, we can't predict the future to tell you whether this is going to change in the next few years, but that's the current state of the law. Lisa, did you have anything to add?
No, not on that one. Excuse me. Next question. Under the new WUCIOA open meeting requirements effective January 1st, 2026, how should the approval of meeting minutes be handled? Specifically, if the board needs to make edits or revisions to the draft minutes before approval at the meeting, can those discussions and edits occur in open session with the homeowners present? Or does such discussion constitute internal board deliberation that must take place in executive session? Additionally, if homeowners in attendance wish to comment on the accuracy of prior meeting minutes before approval, what is the appropriate way for the board to address those comments under the new law? And I'll just say that the short answer to this is just like any other motion, these would be held in open session on the record in the regular board meeting. If you're doing this under Robert's rules, if a board member wanted to change meeting minutes as proposed, they'd make a motion stating what they wanted to change. The board would vote on that change. Then the motion to adopt the minutes as amended would be taken. So someone would say, I move to change the language in the motion from the board meeting minutes of November 1st to this date, to this line and whatever, and then someone would second it, they'd do it, motion carries, and they'd make a note in the meeting minutes that had happened. More often, revisions are requested very informally. There's a consensus of the board to revise it. The motion to approve will simply state revisions are required to the prior meeting minutes, and that's just a line item in the current minutes. In most cases, the owner comment period that was asked about in this question will have already occurred at the board, or excuse me, at the board meeting, because in the meeting section of WUCIOA, it's pretty specifically tailored. The section we're talking about is 6490-445, section 2E. And it says that the board has to provide a reasonable opportunity for unit owners to comment regarding matters affecting the common interest community. They have to provide at least 15 minutes at the beginning of each meeting. And it's for unit owners to comment about agenda items before the board votes. So typically the owners would have already had their time to talk before the time for the board to make motions on things like meeting minutes or any other action before the board. So if a owner had comments on prior meeting minutes, they would have already been addressed at the owner comment period. So that probably, if they had felt strongly about it, it would have already come up. So that would have already happened. And as your question about executive session, you probably recall we've kind of just covered that topic ad nauseum in prior Q&As, but there are very specific topics that are to be covered in executive session, and discussion about board meeting minutes are not one of them. I'll just say that without going into too much detail. If you have questions about what is to be covered in executive session, you can either just pretty simply Google RCW 6490 and executive. Oh, you did? Okay, perfect. I put it in the chat. You just look at there, but if you forget that, RCW 6490 executive, and you'll probably come up with it pretty quickly as well. So I would just say, don't need to worry about that there, but it's just like any other motion. It's just right in the middle of in the meeting in front of everyone, just like everything else is going to happen. Anything you want to add, Valerie?
Well, there's a follow-up question in the chat that I'd love to cover, which is how about approving minutes via email so that they can get those out to owners prior to the next board meeting? And I'm going to use this to beat the drum that I will beat further later in this Q&A, which is that the new meeting section, which will be applicable to everybody in January of 2026, says that all board decisions, substantive decisions, need to be made in open board meetings when notice has been provided to the owners. And I think approval of minutes is probably a substantive decision. Yeah. So I don't think that, I think boards should vote via email as little as possible, period. I've said this for years. The gold standard, even before any of these changes started happening to our statutes, we have long said that the gold standard for making enforceable, documented board decisions is for them to take place at board meetings where you record those decisions in the minutes. For non-WUCIOA communities, up until now, you have still had the ability to make a unanimous board decision in writing outside of a board meeting. But on January 1 of 2026, you will no longer have that option. Every community in Washington state is going to be subject to what has long been the WUCIOA requirement, which is that all substantive board discussion and decisions have to take place in an open board meeting. So I don't think that I would tell a client to do a minutes approval via email. I don't think I would tell a client to do probably anything via email. I mean, if they're voting on, ministerial issues only, and again, I guess I'm sort of jumping ahead to one of our future questions for today.
I think it's the next one, so you could just go into
it. Okay, well, that's fine. I can just do that. So let me just do that. Let me read the question before I answer it, and then we'll be doing things in the correct order here. This is the next question. Can you provide suggestions on how a board can keep up with requests for decisions on ACCs if the board doesn't typically meet every month? Meet every month. Sorry. Many of my boards have done. Nobody wants to hear this. I've been saying it forever, long before the WUCIOA stuff happened. And I'm going to, again, it's going to be my soapbox until I die, I think. The rest of the question says, many of my boards have done the ACC review with consensus through email. Does WCIA allow for that? And the short answer is no, it does not. And so your boards are going to need to meet more often so that they can respond to ACC requests and make other decisions more frequently in order to comply with the statute. When it comes to the ACC issue, the only alternative suggestion that we have is the board can delegate review to a committee, which may have more frequent meetings than the board itself. But if the committee is going to be exercising the authority of the board, it has to have at least 2 board members on it, and those meetings all have to be open anyways. So then at that point, why aren't you just having more frequent board meetings? ACC is Architectural Control Committee, for those that are asking in the chats. If the committee is going to be advisory only, then the committee can review at their non-open meetings, make a recommendation to the board, and then the board has to, at an open meeting, review that recommendation, have any discussion the board might have, and then vote on the architectural review request. So, the sort of reading between the lines of the question and many of the questions that we've got about this topic, yes, this is a change in practice. It's going to feel onerous in the beginning to everybody who isn't used to it. But I want to reassure people, as we have done before, WCIA communities have been dealing with this restriction since 2018 when the statute was adopted. This is not a new thing for WCIA communities. So these communities for 7 years have been holding open board meetings where, all of their decisions have to happen in those meetings, have been restricted from making decisions outside of board meetings in the same way that everybody else is facing. And they've all learned how to make it work. So I'm not saying it's not going to feel weird. It's not going to feel difficult. It's not going to add some administrative burden, certainly in the beginning, to learn how to comply with this. But I think the short version is, if your board doesn't typically meet once a month and you start scheduling monthly board meetings, and you don't just schedule monthly board meetings one at a time, right? Meet in December, set the board meeting schedule for the entirety of next year in advance. Mail that schedule out to your ownership along with a general agenda, which now means you have complied with the notice requirement for every single board meeting in 2026 by doing that, which means you don't have to send out an individual mailing in advance of every single board meeting. And let's say the March board meeting comes along and you have no business to conduct. Cancel the board meeting. The worst thing that happens is you cancel a board meeting that you don't need. But by scheduling monthly meetings, you have set yourself up to handle any sort of decisions that might come up along the way in a way that is compliant with these new statutory requirements. And one of the things that I want to go back to that I was starting to say at the end of the last answer, and then I jumped to this question, is this. The legislative intent behind all of these statutory changes is crystal clear. The legislature has made it very, very, very clear that what they want to do is increase transparency. They want owners to be able to see behind the veil and listen in as the board discusses association business and the board votes on association motions and actions. And so limiting board discussion to meetings is consistent with that legislative intent. Allowing discussion to happen outside of meetings, like via email, and then only doing votes during the meetings is not, I don't think, compliant with the legislative intent. WCIA specifically only allows ministerial actions to be dealt with via email or outside of board meetings. Ministerial actions, sadly, ministerial is not a term that is defined by the statute. But given what we know about the legislative intent, and also given sort of the common definition of the word ministerial, it is a safe assumption. I'm not going to say assumption. It's a safe conclusion that boards should limit their substantive discussion and decision-making to open meetings. So that is true when it comes to architectural review requests. That is true when it comes to any sort of normal business decisions you're making on behalf of the association. I'll offer as an aside that WUCIOA does have an emergency provision, and there is a section of the WUCIOA meetings provision that talks about meetings on a reduced amount of notice when certain circumstances apply. I will suggest that you Google RCW 6490 and the word emergency and actually read the emergency section, because I think a lot of our clients would like to interpret the word emergency a lot more broadly than the statute defines it, which is pretty narrowly. And it's not an emergency when your failure to plan puts you in a tough spot to make a quick decision, right? We've been talking about this upcoming legislative change for months now. You all have been put on notice. All the folks that are, like regular attendees that are Q&A have known about this change for many months now. And if I don't know, insurance related decision sort of sneaks up on you in February and you don't have a board meeting scheduled, I'm not gonna point fingers and say that you're a dummy or whatever for making that mistake. But what I'm gonna say is that doesn't constitute an emergency under the statute. So these are the kinds of things that are just gonna require more planning and a little bit better time management and sort of task and calendar management when it comes to the things that you do on a regular basis, like those types of contract renewals. So I think there's some follow-up questions in the chat. I'm gonna take a peek at those really quickly. If they have approved doing something, but just need to approve the bid or select the vendor, can that not be done by email? We had a conversation about this in a Q&A recently, 2, maybe 3 weeks ago, that you could try to go back and look at. I don't think you can select a contractor. If you have 3 bids or estimates for a project, I think you have to discuss them and make that decision in an open meeting. Now, if you had 2 out of 3 of them before last board meeting and the third one was just late, but you still want to be able to consider it, and you had substantial discussion at the board meeting, and then the board at that meeting voted to delegate the authority to make the final decision to an individual board member and sort of set parameters for, if that third bid comes in and it means XYZ parameters, then we're going to choose that one. But if it doesn't, or if it doesn't meet those parameters or come in, we're going to go with this contractor. Then I think you can confirm that decision by email, right? You can confirm a decision that has previously been made in a board meeting via email. That's not making a whole new decision. But you can't do the review of all 3 contracts and discussion about all 3 contractors and then select the one that you want via email, because that whole process is supposed to happen in your open board meetings. What about approving things like mitigation in response to an emergency and approving costs? I'm going to point you again to RCW 6490, the emergency section. I think if you're dealing with like an actual flood or an actual fire or things that are like legitimate real-time emergencies where, you know, minutes matter in the way that you make these decisions. Some of you have been with us long enough that you know I had a huge flood in my house a couple of years ago. My first phone call was to Ken, and my second phone call, my partner, and the second phone call was to ServPro to come put in a bunch of stuff to clean out the flood, right? Those types of decisions, even if there isn't specifically a statutory mechanism that provides cover for those decisions, those are not the types of decisions that have caused the legislature to make these changes. The legislature is not making these changes because of the once every 5 years emergency flood that requires you to make a real-time emergency decision. The legislature put these changes into effect because there's a perception in Olympia that boards are doing all kinds of business behind closed doors, and they want those doors opened. And I don't necessarily think the majority of boards are out there doing business behind closed doors, or certainly not on purpose, not to hide things from the ownership. But there's enough individual owners that have the ear of folks in Olympia saying that that's happening, that is where most of this is coming from. Another follow-up question, can we cancel open meetings via email? I think you can cancel meetings, yes, via email, put a sign up on the door if it's one where, you know, people were coming in person, put an announcement on the association website or Facebook page or whatever. Yes, I think you can cancel meetings by email. No ACC decisions in a consent agenda. No. I think that's it. So actually there's bid selection. I thought bids were confidential. If not the appropriate, would it be appropriate to list the bid amounts in the minutes? I'm not going to get into that detailed an answer, but competitive bidding is one of the subject matters that's appropriate for executive session. As you can see further up in the comments, I copied and pasted that section, that list of topics into the chat. And if you want us to talk more about this, then send us an email with this question for next week, because we're definitely not going to have time before the end of today. So I think I'm going to be done on this topic for now, just so we can get to the rest of our pre-submitted questions. Lisa, please carry us on.
Sounds good. The next question is, can you review the process of how elections will be conducted if new laws use a secret ballot system? Will members be allowed to nominate from the floor? And if so, how can owners vote from the floor, or will that not be allowed? And I'll start by saying that some of the answer to this question depends on your governing documents to some extent, because the statutes, which when we're talking about, is RCW 6490-455, subsection 4, which has that language, unless the declaration or organizational documents otherwise provide, that sort of magic language that we've talked about before. An association may conduct a vote without a meeting. So that conduct a vote without a meeting language is that what you're asking is the secret ballot system where you're just doing a mail-in vote and we wouldn't have nominations from the floor. So if the governing documents of your association require or allow for nominations from the floor and discuss, that kind of thing, the association would have a meeting where you would have and allow nominations from the floor. But we don't think that in that case, it would allow for voice votes under the new statutory scheme under 6490-455. So you'd still have nominations from the floor, but the ballots would still be done with paper and electronically to keep them secret under the statute. Persons that are on the ballot would not be allowed to see the ballots or the tallies until after the votes were counted and posted, because they are secret ballots. I will note that this section of this statute does not apply to all communities. This is just a WUCIOA statute until 2028. So this is only for WUCIOA communities until January 1st, 2028. There are, as we've talked about before, only certain things apply to all communities starting in 2026, and only certain things apply to certain communities starting July of this year. But as far as your question goes, starting in 2028 for all communities and just for WUCIOA communities right now, if your governing documents allow for from the floor nominations, that is possible, but then the votes would still be secret ballots after the nominations had concluded. So that hopefully that answers your question. Anything to add to that, Valerie, if that wasn't too confusing?
No, I think you covered it.
Okay.
All right, our next question. Can you approve board minutes at an owner's meeting if it's the next meeting, or do you have to wait for the next board meeting? Conversely, can you approve owner's meeting minutes at a board meeting if that's the next one, or do you have to wait for the next owner's meeting? The short answer is you approve the minutes for the previous meeting at the next meeting of the same type. So if it's a board meeting, you approve those board meeting minutes from the last board meeting at the next board meeting. If it's an association meeting, you approve the minutes from that last association meeting at the next association meeting. That's the very short answer. We have previously discussed situations where boards have in a board meeting made a motion to, provisionally approve a draft of the association meeting minutes. And the reason behind this is because under the HOA Act specifically, you must make meeting minutes from an owner's association, from an association meeting, an owner's meeting. You have to make the minutes available within 60 days, but those are going to be draft minutes until the next association meeting, which is presumably a year later, right? And so the board can look at the association meeting minutes and say, we approve this draft provisionally to be shared with the owners so that we can comply with the statute, which says that we have to make these minutes available within 60 days, even though they are in draft form until the following association meeting when the association votes to approve or not the minutes as drafted. I think that's all I need to say. We have a whole lot of detailed bullet points under this question, but I think it's as simple as that. You approve the minutes for each meeting at the next meeting of the same type. And I'll leave it at that. If there's a follow-up question, feel free to pop it into the chat. Lisa,
Okay,
did you have anything to add?
No, I'll just quickly go to the next question. I think it's our last one. Pre-submitted. Our association is being sued in small claims court by a couple who lives in our association. Is the board free to disclose, or maybe even obligated to disclose, this lawsuit, including the names of the people who filed it, to the community? If the association does not prevail, all members in the community association will bear the cost of this lawsuit. Again, this is one of those times I'll say we can't provide you legal advice, and we, of course, don't know the details of what is going on in this situation. But I will say that lawsuits are a matter of public record. So while we generally wouldn't say put owners on blast to all the members of your community, for the reason that we wouldn't want to say, you wouldn't want to shame or put people out in a collections matter, for example. You wouldn't want to put everyone's names out on Front Street, as we would say. Disclosure of their names would not be a legal violation in this case, because, as you said, lawsuits are public records and are available for disclosure to anyone who wants to look at them. If your community is subject to a resale certificate disclosure requirement, when preparing a resale certificate disclosure, you would have to disclose that there was a lawsuit filed against the association under 6434 and 6490 in this situation. And if litigation presented a significant financial risk to the association, then we would typically advise an association that it should be disclosed to the owners. And you'd probably have some disclosure in board meeting minutes at some point to say that there is a lawsuit, and have some discussion, or some mention of it in board meeting minutes, that the association was being sued and that there was some sort of risk to the association, so that members did know that there was that risk out there. I don't know if, we have a note here that there is, I think that's just the statutory, that there is, under the Condo Act, there is a requirement to disclose any pending suits or legal proceedings in which the association is a plaintiff or defendant, and then the WUCIOA has a requirement as well. And so that's the resale certificate requirement. When an owner buys into an association, they do have that requirement to know whether or not the association is a party to a lawsuit of any kind. Anything to add to that, Valerie?
No, I think the emphasis is just small claims lawsuits are a matter of public record, just like anything else. So while I wouldn't turn it into a, like, we're putting these people on blast for suing us, I also don't think the association needs to try to hide it, or that there's any liability created by including information about the lawsuit, like in the minutes or anything else that would be disclosed to the owners. That is the end of our pre-submitted questions. And I looked at the questions that are in the chat, and I don't think any of them can be answered in 90 seconds, which is about the amount of time that we have left. So I guess we just have lots of good seed questions for next week. We want to thank you all for being here, and we will see you next week. Bye, everybody.